Good afternoon, everyone. Hopefully you can hear me. Maybe those who I can see on screen can wave to me if you can hear me. Okay, great. Well, good afternoon, everybody, and thank you for joining us today for Denton's CLE seminar for in-house counsel. My name is Todd Silliman, and I'm the Atlanta office managing partner and co-chair of the U.S. environmental practice here at Denton's. And it's my pleasure to welcome you today. And Denton's is delighted to host this series of CLE webinars. And we thank you if you've joined us for any of the previous installments. If this is your first one, we welcome you, and we're glad you're here with us. Today is the final session in our 2021 series. We've got a great program set up for you today that is both very timely and pertinent. Before we get started, I want to communicate a few housekeeping notes for you. First, presentation materials can be found in the materials box in the upper right of your screen, and you can download them at any point during today's session. Due to the high volume of attendees, all lines are going to be muted. Our speakers will be monitoring the Q&A box, so please be sure to submit any questions there that you might have. There are a few important items regarding CLE credit. Keep the webinar window open and at the front of your screen. This is especially important if you are seeking credits in Kansas, New Jersey, New York, or Pennsylvania, because for those states, you'll need to enter a code word at some point during the presentation. And so being able to view that screen will assist you in doing that. During each presentation, a pop-up box will appear. At that time, our presenters will state the code word and slide with project code that'll project the code word on screen. So if you're seeking credit in Kansas, New Jersey, New York, or Pennsylvania, please enter the word in the pop-up box at that time. Again, this is only required for those of you seeking credit in those states, Kansas, New Jersey, New York, or Pennsylvania. If you do not require credits in any of those states, the code word is not required for you, and you can just close the pop-up box when it appears. CLE credit for this webinar has been approved for 2 hours general credit in Arizona, California, Illinois, Indiana, Iowa, Kansas, Missouri, New Jersey, New York, Pennsylvania, and Texas. And we're pending approval for credits in Georgia, Kentucky, Utah, and Virginia. If you have any questions about that or anything, then you can put that in the pop-up box or follow up with us afterwards. Happy to answer any of those questions you might have. So, with all that put aside, let's go ahead to today's session. Today we have 2 hours of informative presentations, particularly designed for the needs of in-house counsel at the moment that we're in. So first, San Diego partner Peter Stockburger, along with Pittsburgh shareholder Julie Vandeman and Des Moines shareholder Michele Brott, will present on vaccines in the modern workforce. After that, in the second session, Pittsburgh shareholder Alexa Forte and Pittsburgh associate Anna Thompson will talk about immigration challenges and considerations post-COVID-19. We're excited about these presentations today. And with that, I'll go ahead and turn it over to Peter, Julie, and Michele. And again, thank you all for being here with us today.
Great. Thank you so much, Todd, and good afternoon and good morning, everyone, from here in San Diego, California. Again, an introduction. My name is Peter Stockburger. Along with me is Julie Vanneman and Michele Brott, and we will be discussing Vaccines in the workplace, which, as all of you know, even from the news this morning, is a topic that is just continually changing in the news. So we hope this will be an engaging and dynamic conversation for you. We're going to be discussing really the legal landscape around vaccines in the workplace, all the different moving parts that are happening at the federal and state level. And then we'll be jumping into what I think is probably the most important part are, what are the practical takeaways? What do you need to know as in-house counsel around this issue that is constantly changing as early as this morning? Now, before we jump into it, we are just going to do a brief round of introductions so you know who's talking to you in these talking head boxes. Again, my name is Peter Stockburger. I am a partner in Denton's San Diego location. I'm a partner in our employment and privacy and cybersecurity groups. And so my practice really looks at this overlay between employment laws and regulations and how you maintain employee privacy and security. And so this becomes particularly relevant when you talk about collecting vaccination cards and handling confidential medical information. So excited to get into the conversation. Julie, over to you.
Thanks, Peter. I'm Julie Vandeman. I'm a shareholder in Pittsburgh with the Dentons, Cohen, and Grigsby. I am also a co-leader of the National Environmental Practice Group. So part of my practice focuses on environmental law, but a significant part focuses on occupational safety and health counseling. This includes defending employers who face enforcement actions by OSHA, and also a lot of counseling on health and safety issues in the workplace. For obvious reasons, a lot of my practice in the last year and a half or so has focused on COVID. So I'm happy to be here with you today speaking again about COVID. Michele?
Thank you, Julie and Peter. My name is Michele Brott. I'm a shareholder at the Dentons Davis Brown location in Des Moines, Iowa. I'm thrilled to be with you all today to have this conversation that is changing rapidly. My practice consists of employment law, and that's includes advising folks like yourself who make the decisions on how to run your day-to-day business needs in compliance with state and federal employment laws. And then I am also a trial lawyer. So when those risk mitigation policies are challenged, then we take those issues on behalf of management through the court systems. Thank you.
Great, thanks, Michele. So we've got a litigator, we've got an OSHA expert, we've got a privacy expert. So hopefully we will cover all bases here as it deals with vaccines. Now, before we jump into sort of setting the table, I did want to first note that if you do have any questions throughout the presentation, you can type them in the Q&A box. Julie, Michele, and myself will be monitoring that. We'll pepper in questions throughout so we don't have to wait until the end of the presentation. Of course, at the end of the presentation, if there's time, we'll address any additional questions. So please don't be shy and fire away. To get things started, we just wanted to give you a brief overview of the legal landscape around vaccines in the workplace. This is so you can sort of have a baseline understanding of what the law requires, what it permits, and really what are the practical considerations. From there, we'll jump more into detail around the OSHA, ETS, the CMS rule, the federal contractor rule to get into the weeds a bit more. But from a 10,000-foot level, we really think there are 4 key questions when thinking about vaccines in the workplace. 1, are you allowed to do it? 2, are you required to do it? 3, should you do it? And 4, can you encourage people to get vaccinated? So, the first question, which I think is a very important one, are employers allowed to mandate the vaccine? The universal answer to that as a general rule is yes, with a few caveats, which of course is always the legal answer. The EEOC at the federal level, the state counterparts, for example, here in California, the California Department of Fair Employment and Housing, have said that employers can impose vaccine mandates on their workforce so long as they comply with other federal and state laws relating to accommodations, specifically medical and religious accommodations. And so that's an important caveat. According to the EEOC, if someone raises a medical disability reason why they can't get the vaccine, you have to engage in that interactive process, understand what the medical condition is, understand what the job position is, and can there be a reasonable accommodation. Now, most folks right now are not back to the physical workspace full time, so reasonable accommodations often look like remote working in today's environment. It does become a bit more complicated when you talk about people who need to be physically within the workspace, especially when you consider essential workers, people working in the mailroom, IT services, front desk, and navigating accommodations for those folks can get a little bit thornier, which we'll jump into a little bit later in the discussion. Some other limitations on are you allowed to do it is collective bargaining agreements. If you have a unionized workforce, those CBAs could very well have restrictions on vaccine mandates and the like. And we see that a lot in the healthcare space. It's becoming more an issue in the non-healthcare unionized spaces as well. One important caveat limitation is around conflicting state and city rules, which we are seeing more and more of, especially in some of the so-called red states, Florida, Tennessee, and the like, where you are seeing restrictions from the government, the state government, on private employers saying you cannot require employees to get vaccinated. Or, in the case of Texas, adding additional accommodations, additional reasons why people can opt out of the vaccine. For example, in Texas, the executive order there talks about personal conscience, which is not something recognized under general federal and state law. So being aware of those state and local requirements is critical when looking at are you allowed to do it. And then finally, are you allowed to do it? Well, employee resistance, retention, it's a topic we're going to be talking about throughout because I know it's something, Julie and Michele, you deal with a lot with clients, and that is, yes, you can mandate the vaccine. Yes, you've got the capability to it, but your employees don't like it and you're going to lose part of your workforce. So what's the balance? What's the right thing to do? What's the operationally difficult thing to do? An important question to keep in mind. So that's the sort of landscape on are you allowed to do it? General answer is yes, with some caveats. The more difficult question right now is, are you legally required to do it? And that's what we're seeing all the changes in the news right now. So we've got an OSHA healthcare emergency temporary standard that's been in effect since the summer that's shortly running out. We've got a new OSHA ETS that I'm sure everyone is aware of that has a vaccine or testing and masking requirement that is currently pending in the Sixth Circuit, and there's a lot of legal ambiguity about whether OSHA is going to be able to enforce it. There are states that may start imposing their own vaccine mandates under OSHA-approved plans, California being one of them, although California, as of last week, indicated that they're going to hold off until they see what happens in the Sixth Circuit with the OSHA rule. You've got the federal contractor rule that President Biden issued through executive order, which is also enjoined now in 3 states, as of, I believe, yesterday from a federal court in Kentucky. And we have the CMS rule applying to many healthcare settings, which as of this morning has now enjoined nationwide by a federal court in Louisiana and was also enjoined yesterday by another federal court. So it seems that all 3 rules are currently under legal attack. And of course, you've got individual state COVID rules that talk about masking. So are you legally required to vaccine your workforce? Potentially. It's an open question. It's a frustrating answer, but that's the reality. And we're going to dig into these federal rules in more detail. Michele, I want to toss it over to you to maybe go through these second 2 questions on should employers do it, and then what are the rules around encouraging folks to get the vaccine?
Thanks, Peter. Yeah, I appreciate that intro. So we've covered, can you, and we've covered are you required to, and then it comes down to should you. And this is a complicated question that's got a ton of different factors piled in. We talk a lot when clients call about who are you and where are you, right? Are you in a high risk, high exposure setting? Are you amassing hundreds of people at the same campus or location on a daily basis? Are they working in close proximity? Are you in an area that is suffering from increased community spread? I know community spread's everywhere and that word gets overused a lot. But, for instance, I have clients who are the large employer in a rural area. And so they work closely with the local healthcare systems and closely with their COVID mitigation or their COVID floors. And when the COVID floors are getting full, they ask us to really buckle down on our COVID mitigation because we are employing the vast majority of the residents who are seeking healthcare in that particular area. That, of course, spills over into schools and other employers in the area because we're bringing together so much of the community. In my state, we have a lot of folks who have returned physically to the office. And so we are seeing these issues bubbling up with mixed settings, right? So we've got some folks who want to come to the office who are not vaccinated, and we have folks who are in the office who are vaccinated, or the workplace or wherever it is. And there's tension on both sides of that coin. And we cannot have this conversation without considering the labor shortage. I don't know anywhere that is not suffering from the fact that it's difficult to fill positions and it's difficult to find to replace someone when they're gone. I have a client who told me when the mandates came out, Michele, I'm already running 25% below my preferred headcount. If I lose any more, I got to put a padlock on the door. I can't do that. We cannot operate safely if we have any more folks walk out, and they are heavily unionized, and they believe that their union is not going to want to negotiate with this. That is a real life, everyday, right now problem. And their employees wanted to know their position on the vaccine mandate rules. We were able to sort of massage that messaging that we hadn't quite made a decision yet. But we also can't talk about labor shortage and retention without talking about recruiting. Many who are in the job market are getting used to seeing on job descriptions or on job postings that vaccine is required for this particular job. But are you in direct competition for labor? Are your competitors requiring vaccines? Is that going to be more attractive to your candidate pool? Alternatively, are your competitors being more flexible with their vaccine stance? And is that going to draw the talent? All of those factors. Have you not recalled much of your workforce? Do you have folks who are spread out across the country? Are you able to keep people at home? If so, then maybe this isn't the biggest bubbling up issue that you've got. But if you've got the people who are coming back, and as we'll talk about, it's going to come down to somewhat of that micro level, that one whistleblower is what's important here as far as getting your company on OSHA's radar. Did I do too much or did I do not enough? Changing positions, that's been a big problem. Obviously, the law is changing rapidly. So when we start to communicate with our employees, as we constantly have through COVID, reminding them that change is coming and that we don't know what that change looks like because we're responding in real time. It is difficult to unring a bell. It is difficult for the employees to think that things are going to be one way at the office and then another, because that has real life implications too. So we amass these variables together when we start talking about, should you mandate the vaccine?
Michele, just a quick point on that. On that changing positions, it's something that I'm seeing constantly with clients, which is they're getting more employee frustration and more employee questions if they're changing their position constantly. So, I think being conservative about how you're pushing out communications, digesting new rules, new legal developments is critically important, because that all of a sudden the confusion creates frustration, can create whistleblowers. So that consistency in communication is definitely an important takeaway, I think, for everyone listening.
Excellent point, Peter. And, I'll tell you that part of it is also employee driven, right? We're all watching the news. Everyone watches or sees the headlines in their world. And we've had a lot of employee-led conversations. I want to know what this company intends to do about these vaccine mandates I'm hearing about. And they may be pressing you for an answer before we've decided. And so recognizing that we don't want to leak out maybe what we're thinking right now, when that very well could change. A month ago, you would have said, hey, look, we're a federal contractor or we're a CMS provider. We're not going to have any flexibility here. Now we have stays in a variety of states on those rules. So being forced into the conversation prematurely is another issue that you want to put on your radar, and the folks who are having the frontline conversations. On the topic of, can we encourage people to get the vaccine? 6 months ago, this is exactly what we were doing, was this encouraging and educating, incentivizing. And I think that's completely legitimate. I think it's a fantastic idea, but we have limitations like we always do. Incentives are fine and are fair game. For a while, there was a lot of concern that if the incentives were too rich and too generous, that it would feel like compulsion. I'm not sure, and I'll kind of look to my panelists if they have any thoughts, but with the state level kind of $1 million drawings, I'm not sure that that is as heightened of a concern as it once was. It's certainly, you don't want to have some sort of compulsion type debate with your employees, but I'm not sure that that's as big of a concern as we once had. Disincentives, right? We've seen this, that if the carrot doesn't work, then we can also try the stick. And the surcharge on health insurance is just a great example of tying it to something that's legitimate and makes sense in a business model. And, you know, I've seen internationally that there are countries who have chosen to fine residents who are not vaccinated. Certainly we won't do that in the United States, but an employer may. A surcharge is not entirely different. I haven't seen anyone do that. It's an interesting idea. But again, the carrots and the sticks balance to try and increase the vaccinated numbers. Inconvenience, right? Regular testing and masking. You want to be careful with inconvenience and disincentives because of that last bullet point there on discrimination and retaliation. Whenever somebody's exposed to something that they think another member of the workforce doesn't have to do, they start asking why. And they start drawing comparisons. And we want to look at, have we set ourselves up for intentional discrimination or retail claims? Keep it on your radar. Biggest issue, disparate impact, right? Unintentional by definition, a facially neutral policy that we put into place with the best of all intentions to keep our workforce safe. You know, regardless of how you feel about vaccines or how your workforce feels, I think we all agree that COVID can disappear anytime, that it is causing not anything positive for the workforce and for the economy. So if we all rally behind, you know, sort of that notion, then it is, but how do we get there, right? So making sure that your eyes are, just because you're trying to come at a policy from a generous place to make sure you have a safe work environment, that you don't want it to go too far.
Great, thanks, Michele. And I think from there, with setting that table, we're going to toss it over to Julie, our OSHA expert, to dive into the OSHA Healthcare ETS, the new OSHA ETS, and some practical takeaways there. Julie?
Thanks, Peter. So I will try to make this relevant, even though we know that some of these rules are not enforced across the country. I think it's still relevant to know what the requirements could be if they do go into effect. And as we'll discuss later, there's some practical implications that can be learned from them. So starting with a brief background on OSHA. OSHA is part of the Department of Labor. It covers most private sector employees in all states. It's important to understand whether you are in a state that's covered by the federal OSHA or by an OSHA-approved state plan. There are 22 states that have their own state plans. This means they have to have rules that are at least as stringent as the OSHA rules. So it can't be more lax. It can be more stringent. And there are some states, such as California, Peter, that are known for being more stringent than the federal OSHA rules. You may have heard about some issues with this recently. So for example, there were 3 states that were dragging their feet on enacting an equivalent version of the OSHA Healthcare ETS. So OSHA started going after them and saying, if you don't do this, we're going to withdraw the approval of your OSHA-approved state plan. This was enough to encourage, I think, South Carolina recently to get in line. You may have also heard that Florida is investigating the possibility of having an OSHA-approved state plan because it does not like the OSHA ETS for 100 or more employees. Florida can certainly consider that, but OSHA is not going to approve a state plan for Florida if it proposes a standard that is less stringent than the national standard that OSHA has proposed. So just keep in mind those issues about state plans versus the federal plan.
Hey, Julie, a quick question a quick question on that came in is, so for example, in a state like California with their own Cal OSHA, for this new OSHA ETS, even though the federal ETS is bogged down in federal courts, California is free to come out with their own vaccine mandate, free and independent of OSHA. Is that right?
Yes. So, for example, Virginia was the first state to develop its own ETS. So, the acronym ETS is slightly confusing because it's been overused. Virginia had an ETS months and months ago, and it has particular rules for what you have to do in Virginia. This is understandably what makes it challenging for employers that have multi-jurisdictional employment sites, because you have to know what the rules are in each state. So yes, a state could decide to be more stringent than the federal plan. Exactly. So we're going to be talking about standards, and an emergency temporary standard, or ETS, is one such standard. But I want to pause for a moment and talk about Section 5A1 of the OSHA Act. This is colloquially known as the General Duty Clause because it generally provides a duty for employers to provide a safe and healthy workplace for their employees. It's an employment that's free from recognized hazards that are causing or are likely to cause death or serious physical harm to employees. So even if there is no specific standard about OSHA, about COVID, OSHA is still free to institute an enforcement action based on the General Duty Clause. And there have been such enforcement actions throughout the COVID crisis, where companies have taken what OSHA considers to be inadequate steps to protect its workforce. So don't forget, even if the ETS goes away completely and there is no federal standard about COVID, OSHA can still investigate you for General Duty Clause violations. Standards are more specific. I deal with a lot of manufacturing clients, and I'll just have an aside here that both Peter and Michele talked about return to office, and I understand that's a concern for a lot of you, but I also have manufacturing clients and clients in other sectors where people have been going to the work site from the beginning. Either they never left or they've gone back a long time ago. So this is really an issue that has been ongoing for some time. OSHA may issue standards, and they're often very specific, pages and pages long, with very particular rules about what companies must do. And that's what OSHA is trying to do for COVID. As an aside, there have been plans in place for quite some time to have an infectious disease standard generally. That does not exist yet. OSHA doesn't have the resources that it would like to have to develop all the standards that it thinks might need to be done. As an example, OSHA is currently investigating whether there should be a heat standard. So for those of you who are interested in heat issues, that's currently pending. But back to COVID. So an ETS is only possible when there's a grave danger due to exposure to toxic substances or agents that are determined to be toxic or physically harmful. So the OSHA ETS right now is undergoing challenges, as we know, and it has been stayed. So it is not in effect, but we're going to go over it anyway, in part so that you're ready for it, and in part because some of the lessons learned about it could be helpful in developing policies generally. But I'll start with a healthcare ETS. And again, like I said, the acronym ETS is overused. But this is the first ETS that OSHA issued, and it's just for healthcare facilities. It took effect in June. It has a 6-month time frame. That means it's almost about to expire, but it is currently in effect, and it applies to covered healthcare employers. As with any standard, one of the first questions that you have to ask is, does this standard apply to me? Because all of the considerations about how to do it, what's exempt, what it requires are meaningless if it doesn't apply to you. So it's definitional. The first thing to do is to check to see if it applies to you. If it does, there are some requirements that are very OSHA familiar to those who deal with OSHA, including preparing a hazard assessment plan. So you go through your workplace, you figure out what the hazards are, and you develop a plan specifically to address them. This is obvious in the healthcare context because of the risk of transmission of the virus that causes COVID. So there are provisions in there, such as the need to use certain personal protective equipment or PPE. One of the provisions in here is about providing paid time off to get vaccinated. This is going to seem familiar to those of you who have heard about the other ETS, where that is also a requirement. In the healthcare context, there are certain exemptions from control measures, such as masking and physical distancing, for employees that are fully vaccinated in certain contexts. So one of the advantages of vaccination for employees is they get to drop some of those control measures, which are certainly doable, but people object to having to do them for hours and hours and hours at a time. So that's one of the benefits of the healthcare ETS is it explicates when you can drop certain control measures.
Hey, Julie, before we move on to the
Yes.
the OSHA general ETS, we had a question that came in on your previous point about states with their own approved OSHA plans not being as stringent as an OSHA ETS. And the question is, if a state does not have an ETS that's as stringent as the OSHA requirement, does that mean from a legal standpoint, does the OSHA rule then completely sort of displace the state rule, or is it just the provisions that are in conflict? How does that work legally?
So the state gets a certain number of days to adopt a plan that is in conformance with a federal plan. So the state is going to have to decide what to do. Does it adopt something new entirely that displaces what it previously had and adds on? Or does it adopt something that just adds on to what it already has? I would think the state would want to be clear and not be confusing as to what used to apply and what applies now. So I would think that they would want some sort of systemic effort to rationalize the requirements that they think are necessary, as well as the ones that OSHA is requiring them to have. And they get a certain number of days to do that. All of those deadlines are a bit fuzzy right now because of the stay. So I'm sure that states like Virginia and California are deciding what to do and looking at the OSHA plan and considering whether they think that it's stringent enough for what they want to do and deciding where to go from there.
I'm sure, like with everything else COVID related, it'll all be very clear and there will be no questions once the state issues their rule.
Right, exactly. And don't forget, one of the issues with COVID is that, I've worked with OSHA for quite some time, right? So I look to OSHA for guidance and rules about what to do. But when COVID hit, a lot of those rules were coming out of maybe the state health department or the local health department. So it's not just looking to one authority for what you need to do, it's looking to a number of different authorities, which makes it challenging for employers to make sure they have the full suite of options that they need to consider.
So what about this OSHA general ETS, the one that's on everybody's mind, the ping pong, it's pending in the Sixth Circuit? Julie, walk us through that, and I'm sure you have a crystal ball and know all answers about how this rule is going to end up.
Exactly. So the OSHA ETS, yes, it took effect on November 5th, but it is not actually being enforced. So all the deadlines that are in there are a bit fuzzy right now. The first deadline to comply is December 6th. That is the deadline for most of the provisions in the ETS. This includes measures such as providing certain information to employees, providing time off to get fully vaccinated, having a written plan, having a roster so that you know who's vaccinated and who's not vaccinated. All of those things are supposed to be in compliance by the 6th. However, the briefing schedule, the last I checked, meant that briefing wouldn't even be finished until December 10th. So the likelihood that enforcement will start as of December 6th seems quite slim. The parties have been going back and forth about the briefing schedule and who wants what and how long it will take and when they're going to get to the merits finally. But it does not seem that likely that December 6th will actually be enforced. That said, it doesn't mean you can't go ahead and be compliant with many of the provisions by December 6th. So for example, by December 6th, you're supposed to have mask requirements for those who are not fully vaccinated. You may decide to do that anyway. And to explain why, I'll refer back to what I noted before, which is the general duty clause, right? So you're required to provide a safe and healthy workplace for employees, even without a specific standard. So you may decide that to provide that safe workplace, you need to have masking requirements for unvaccinated people, even if the ETS is not in effect. I will add a couple of caveats here, which is that we previously were counseling clients for the most part that you could go ahead and collect vaccination information so that you could be ready to produce a roster when required. And one of the reasons for this is that OSHA's compliance rules are really quite strict. So you don't get much time as in just a few hours, to produce the roster if OSHA demands it, assuming the ETS is in effect. However, Tennessee recently passed legislation saying you are not supposed to collect and store vaccination cards. So before you go about doing this, it is important to understand the jurisdictions in which you operate to make sure that you're not violating a state or local rule before you go ahead with attempting to be in compliance with the standard that you expect OSHA to be enforcing perhaps later.
So Julie, in that context, let's say I'm an employer in Tennessee. The OSHA rule is not being enforced technically. The stay is still in effect. The legal challenges are pending in the Sixth Circuit, but I have a Tennessee law on the book saying don't collect vaccination cards. I guess in that scenario, my only choice is to not collect vaccination cards because there's no conflict between state and federal law at that point. Is that how you would view it from an OSHA standpoint? Or do you think OSHA, if the stay were lifted, OSHA would come in and say, hey, you should have been collecting vaccination cards since the beginning?
OSHA generally wants to know that you're making a good faith effort to comply. And I think an employer in Tennessee would have a reasonable argument that they're making a good faith effort to comply without violating a state law. So there are things that you could do. You could collect voluntary information on vaccination status without collecting the proof of vaccination that OSHA actually requires. If you look in the regulation, there's 6 different ways you can collect proof of vaccination that are satisfactory, starting with a vaccination card, but there are other ways as well. So you could collect information about status without collecting that. So you wouldn't be in compliance with OSHA, but you would at least be trying. But understanding that the deadlines are likely being pushed back and understanding that Tennessee has this law in effect, I think OSHA should be understanding that you're trying to not violate state law. A couple more points about the OSHA ETS. Again, like I said before, with an OSHA standard, the first thing you do is check if the standard applies to you. So it's 100 plus employees, and I can get into that if people have questions because that can be a little bit challenging. But it's also good to note that it does not apply to employers who are covered by other mandates. So the regulation specifically says if you're covered by the healthcare ETS or the federal contractor rules, this ETS does not apply to you. What's going to happen when you're not covered by those other rules because they are not in effect? Then you all of a sudden have to start thinking about the ETS again. But of course, as we've said, it's been challenged by multiple states, and the consolidated challenges are pending in the Sixth Circuit. The government actually, or some of the parties actually asked it to be transferred to the DC Circuit. I haven't heard on what happened with that. As far as I know, it's proceeding in the Sixth Circuit. I don't have a crystal ball, as Peter said that I might. I don't know what will happen. I think there are some concerns with the OSHA standard. And honestly, based on OSHA's track record, they don't have a great record in terms of prevailing for challenges to OSHA ETSs. So the track record is not great. That said, this is a pandemic. There is no track record for dealing with a pandemic. So there's a lot of uncertainty out there.
So Julie, Michele, maybe you can sort of kick things off here. I guess we've titled this slide as practical advice on the OSHA ETS, but Julie, per your point, it's really up in the air whether the ETS is going to be enforced. But these 3 columns of practical considerations really apply across the board, regardless of whether the ETS is going to be enforced. It really applies to all employers considering vaccine mandate, testing requirements. So Michele, maybe you could kick things off and sort of walk through how, as an organization, should you be thinking about operating a vaccine or testing program, and what do you do about exemptions?
Thanks, Peter. Yeah, these are the questions that we've been answering and working on for a long time, right? Even before September, when the executive order, the ETSs, the regulations, everything was advertised that was coming. The first one is, how do we collect vaccine cards and how will they be secured? So there's all kinds of different methods. It depends on who you are as an employer. But what you need to remember, certainly coming from the legal perspective, is that these are confidential medical records. They need to be stored like any other confidential medical record of an employee. I'll tell you, we're commonly accepting smartphone uploads, right? You know, somebody snapping a pic and providing it with to us is an easy way to make sure that we get a copy. And I will tell you, I think Julie made the point about that there's a Tennessee law. You know, in Iowa, we have a law that suggests that it doesn't allow vaccine cards to be collected, but a careful reading shows that you can. So the state law is all over the place, and there are some political compromises that are clearly buried in the law. So even though it looks like perhaps we couldn't collect them, I think the answer is pretty clear that we can, or that an employer can. So, and then Peter, from a privacy standpoint, I know you've got some experience to provide as well.
Yeah, when you're collecting vaccine information, whether it be a card or even vaccine status or testing results, there are two important considerations to keep in mind. One, under the ADA and most state counterparts, that's going to be considered a confidential medical record of that employee. What that means is that it has to be kept separate from the personnel file, and there have to be what are called access controls around that data. That means where it's stored, whether it be a database, a third-party app, a shared file, a local drive, only those individuals with a need to know that information have access to it. So, for example, if you are storing vaccine information on a Workday platform or another shared platform, and everyone in the department has access to that platform, and you haven't imposed administrative access controls, you may be running afoul of the ADA and state law with regard to the access to that information. That's point one. The second point is you have to be aware of this growing body of law at the state level that are around consumer data protection laws. In particular, the one that really applies is California under the California Consumer Privacy Act of 2018, which took effect on January 1 of 2020. Under that law, job applicants, independent contractors, and employees are entitled to receive a notice at or before the point that their personal information is collected. And that notice must explain what's being collected and how it's being used. The definition of personal information is broad enough to include thermal information, which includes temperature reading, any medical information, which would include vaccine or testing status, and basically any information that could be possibly tied to the individual. So if you are in California or you're doing business in California, you've got employees there, before you collect vaccine or testing information, you got to be sure to look at, do we have to provide a broader notice at the point of collection? And I think those 2 points, Michele, are real important caveats, because as you roll out your vaccine and testing program, it's very easy to forget about the privacy notice components when you're doing so. And that really could introduce bigger liability sometimes than just collecting the card itself.
Yeah, I think it's a great point, because this is where a lot of the tension lies, right? Between what the vaccines are viewed as the safe, as a safety mechanism, right? That COVID-19 poses a threat in the workplace, and that a tool against mitigation is vaccine. But part of the tension comes from freedom and security and privacy, right? That it is being certainly ingrained into us through the digital age that we want to protect our privacy. And there is a lot of tension with that particular revealing of one's information. And so I think the privacy considerations really respond to some of those employee concerns and provide them some assurance that we are thinking about privacy as much as we're thinking about safety, and we are juggling all of those very important considerations.
Yeah, I think it's critically important to tell employees, just briefly, it's important to tell employees, what are you going to use it for and how are you going to keep it safe? Even if you're not covered by California law, you should be telling people that, because that's the number one question they have. Okay, if I tell you I'm not vaccinated, are you going to use that against me? Am I not going to get that promotion? Am I going to get fired? If you're only using the vaccine information to determine access to the workplace or compliance with federal law, I think it's important to be transparent about that, because that's usually one of the FAQs that comes in.
Great point. So as we move through the process, okay, so what are we going to do for time off recording it and ensuring time off is properly provided for vaccines. Okay, so are you giving time off to get vaccines and allow for recovery? Depending on which mandate comes into play, isn't stayed, is stayed, comes back, overruled, whatever the changing status of the law. If you are providing time off, I think you'll hear me say a few times, point of contact. Throughout COVID, the consistency of who's making the decisions has been one of the best practices. We did this during quarantining and exposure calls. You want to have sort of a point of contact or a committee of points of contact so that they get a feel for what the company is doing so that we're consistent. I think the same thing is true for dealing with vaccine administration and vaccine testing programs, and certainly with exemptions too. This point of contact, whether that be an individual, whether it be a group, a committee, depends on your volume and depends on who you are as an employer, is critical for that, so that they can provide the consistency and ensure that those messages are delivered. How are you going to run a testing program? Well, the first point of this slide is how you know how big your testing program is going to be, right? Who's vaccinated, who's not, who do we need to test? And when we learn the percentage of unvaccinated workforce that you have, and if you're going to go ahead and do testing, which I had a number of healthcare clients who, even though the CMS regulations did not require testing, they felt that was part of patient care, was to also provide require testing so that there was an additional check in the process for unvaccinated employees, or for those with accommodations, really, is what that would end up being practically. But if you're going to run a testing program, how big does it need to be? For my public employers, the question was, well, I need to have this in the budget. And so, what is this going to cost and who's going to pay for it? And if it's going to be us, how much? You have to also then decide, are you going to allow new hires to be unvaccinated other than with an accommodation? So do you just have a grandfathered group of current employees? Is this going to be a static and fixed cost? Are you going to, I have a client who said that they would pay for 2 weeks of testing or 4 weeks, because that allows you 1 month to do your homework and decide if you want to be vaccinated or not. And then if you choose to be vaccinated, then we'll pay for the testing throughout the course of your becoming fully vaccinated. Alternatively, if after a month that is a choice that you make, then it would also be your cost. You may have seen that throughout the various mandates, it was sort of blessed that we could pass the cost along to the employee. That differs by whether you are choosing to do that. It also differs by state law. And remember, if you've got individuals working from different states, if you have expanded your footprint because of remote work, then you've got to look at all of those states and determine what state law applies. So if you can pass the cost of the test back onto the employee, what does that look like? Where are you going to source them? Again, how many are there? Can you withhold from a paycheck? That is also a state law consideration. And what tests are acceptable? I think it's pretty clear that antigen tests are not. And antigen tests are the ones that test to see if there's antibodies for COVID, if you've had it and you've got some of that natural immunity. But any other diagnostic testing has been okayed by what we have certainly from the federal government. But the self-tests, right, the ones that you can pick up from a drugstore, are fine as long as they're diagnostic. And if they're going to be self-administered, then they have to be proctored, which was a very attractive option for a lot of my clients, certainly. We can set them up. We've got health rooms. We've got, places where we can bot people in. We can have it proctored, do it on a Friday afternoon, get you ready to rock and roll on Monday to comply with that, safety component. Those are the types of logistics, because even if you were not going to put in, if you were under the 100 employer test or under employer rule, and if you're not going to put in a mandatory plan, you're still going to change the workflow because you're going to have this additional testing component.
Yeah, Michele, one consideration from a state like California too is how do you keep track of the timekeeping when people are out of the office, getting tested, getting vaccinated? I mean, we have a rule here that it's not just 40 hours in a work week, it's over 8 hours in a work day, you get overtime. So are they entitled to overtime? And then there's a workers' comp issue that I see coming up a lot, which is if somebody gets injured at the testing site or getting vaccinated, or they hurt their arm, or they get sick. I think a lot of people I've heard people reporting getting sick from getting the booster and falling ill. is that a workers' comp claim? What's your insurance look like in that space? So a few anecdotal notes that I'm seeing in California on this issue.
Those are great points and a lot of unresolved questions. I had a spirited debate internally with my healthcare colleagues because they remind me that we don't have to pay healthcare workers to get their TB, and that they can be sent off to get those type of inoculations, and that's not required to be compensable time. But I'm like, I don't know. I think it's suffered or permitted under the Fair Labor Standards. If we're forcing someone to be tested, if we send them off to get a random drug test, they're on company time. So we had a pretty spirited debate internally about what that looks like. And I don't think that we have a clear answer. I think there's a bit of appetite for risk. On the one hand, do you not pay it and wait to then be owed the time? Feels a little class action like to me. That feels like there could be some risk there. Again, depends on how big your pool is. If you can set up testing with a preferred vendor, then maybe it's not as important. Maybe it's less of a consideration. But if you are required to send somebody 20, 30 minutes across town and they're sitting at a testing site for 2-3 hours, you have a problem. You're doing that with how many employees times how many weeks. You have a very serious question about whether that's compensable time and what type of risk would be on the backside of it. And then moving right into discipline for noncompliance, right? Because this is where sort of the stubbornness and if I choose not to type of conversation can come in. And that again is, OSHA is going to want to see that you're making that good faith compliance. You don't want your rules to be toothless. You want none of your rules to be toothless. In a litigation standpoint, if I find out you're not enforcing important safety rules, if we have litigation on something else entirely related, that can be fodder and that can be proof of how seriously you control risk and how seriously you control employee rights in your workplace. Not to mention the morale considerations for the other employees who are complying with rules and, can see the disparity in enforcement. So it depends on who you are and what you decide. You can follow progressive discipline. You can treat it as a violation of a safety rule. You can treat it like a hard hat rule, 0 tolerance. If we find you without it, then you're off. We can suspend you from the work site. We can send you home. We can cut ties. We can do all of those things. But whatever you decide to do, make sure it's consistent. And whatever policy you write, make sure that it is one that you're going to make sure is enforced. I'm going to jump right over to exemptions just in the interest of time because there's just a ton to cover here. And Peter and Julie, please interrupt me because I'm going to keep talking so that we get this information out to all of you, but I don't want to cut my colleagues off. But talking about exemptions, we're looking at religion and medical here, right? And some of the biggest issues are that religion is a broad, intentionally broad, and somewhat undefined subject under federal law. It is not limited by organized religion. I think we all know that. So there's a lot of concern that reluctance to get a vaccine or political stance against a vaccine is being bundled up into religion. Prior to COVID, I didn't have a bunch of religious exemption cases come across my desk, as it turns out. But it is certainly going to become a contested and litigated issue. We see employers choosing to do things on the spectrum. Some are over here where they are very lenient. And we have a 2-question form where it's open-ended. Just tell us your religious beliefs. We're not going to go through an exacting standard. And then I have other employers on the other end of that spectrum that have 30+ questions, really challenge the consistency of the purported sincerely held belief and pull out where there are well-known sort of inconsistencies. If someone says that they're concerned about fetal cells and abortion context to vaccines, pulling out other examples that where have you been consistent on this belief and stance throughout recent history? Because case law does recognize that just because you weren't as devoted to your beliefs at one point in time doesn't mean that your beliefs cannot change and evolve. Case law does recognize that. What constitutes an undue hardship? So it depends. Are we talking about religion or medical, right? So the standard is easier for an employer to deny a religious accommodation than it is for medical. The standard for religion is an undue burden that is more than a minimal cost. Alternatively, for medical, it has to be a significant expense or difficulty, right? So it depends on which one you're looking at. Again, I'm going to make a pitch for a committee, either a committee or a consistent point of contact for who's reviewing these exemptions. I have clients who will review them internally, and if they're granting them, then they don't involve counsel. But if they're going to deny them, then that is an automatic check in the process that they come to outside counsel to make sure that there's a fresh set of eyes to determine whether they're being, in compliance with the law at that juncture. Clients have asked, what about the people who they feel are rubber stamping exemptions? I don't know what OSHA, I don't know what CMS will do with those types of seemingly rubber stamps. I was hoping to hear from the EEOC on this particular point, but given all of the stays and injunctions, we haven't. There's a ton of local laws cropping up. Peter mentioned one earlier. Iowa has one. It talks about that if you want to just make an attestation that you believe the vaccine would be injurious to yourself or others in your household, which I don't know how that works, but you can make that statement, and that is under state law. Meet your burden so that you are exempt from the vaccine laws. So there's a whole mishmash of different types of state law coming up and different considerations. I'll give the plug for the interactive process. Remember, we're resolution oriented. Even if you are suspicious or concerned about the number of exemptions that are coming in and you're concerned about safety and making sure the vaccine program is successful, that interactive process is key. We can find all kinds of ways to solve a problem so that we meet everyone's needs. Julie, a little bit on enforcement.
Sure. So I'm going to cover enforcement quickly because we're running out of time. But while I'm talking, I'm going to forward to the next slide, which is the code word, so we can get that done. So you should see the code word popping up for those of you who need it. And while you're looking at that, I'll just keep talking about enforcement. OSHA is an understaffed agency. There are fewer than 2,000 workers across the country who run out and do inspections. I read somewhere it would take 160 years to inspect every workforce if that's what OSHA chose to do. And they've actually lost 14% of their own staff in the last 4 years. That said, OSHA can investigate you, and it's no fun if they do. So one of the issues that happens is you can have whistleblowers who have OSHA, who bring OSHA's attention to you, which is something you're going to have to deal with very promptly. OSHA's timeframes for investigations can be quite quick. Penalties can be severe. There is provision in the Build Back Better legislation, which I know is still in proposal phases, to increase them dramatically. So for those of you who are not used to dealing with OSHA, this could all be a surprise, particularly for the compliance requirements that are very strict, such as the number of hours that you have to produce a roster if the ETS goes into effect. I want to address one question really quick that came up in the chat, which is, what about wearing masks for fully vaccinated people? So that is actually not an easy question, because OSHA's guidance says that when you are in an area of high or substantial transmission, you should make everyone wear masks, both vaccinated and unvaccinated. That's guidance. It's not a rule. You don't have to follow that rule. That said, generally, if you are not following guidance that OSHA puts out there, it's harder to defend you if there's an enforcement action by OSHA against you. So one of the things that I will mention is that we're so concerned here with people who are unvaccinated. But one of the concerns you have to keep in mind are people who are either vaccinated but maybe immunocompromised, or vaccinated and worry about transmission in the workplace, or just concerned that you're not following proper procedures. Those are the people who might call OSHA in to say, my company is not doing enough to protect me in the workplace. And then you might have an OSHA enforcement action to face. So that's my very, very quick review of enforcement. Obviously, it will depend upon whether or not the ETS actually goes into effect. I'm also going to very quickly cover the federal contractor rule by saying it has been blocked in 3 states, but it is still going forward in more. It's a true mandate, which means you actually have to mandate the vaccination, have the exemption process. The OSHA ETS is not a true mandate. With the OSHA ETS, you can choose to have a mandate, or you can have a test and mask rule. So I think they're really quite different in terms of the implications and the choices that employers have. The CMS rule was just blocked across the country very recently, today or late yesterday, this morning. So I'm not going to cover it. Aside to say, that is a very strict rule as well in terms of having a mandate and how a compliance is assessed. So stay tuned. I think a lot of companies are continuing to plan for that, even though it is temporarily held in abeyance. Peter, I'll toss it back to you. That was a very quick review of a few slides there.
Yeah, not a problem. We're coming up to the top here, so I wanted to make sure that the three of us were able to give sort of our key takeaways to everyone who's been patient and hanging out with us for this past hour. A key takeaway from myself is around the privacy and cybersecurity component. You've got to pay attention to that, and increasingly clients are looking at developing privacy programs, privacy-specific notices for employees. It is very important to keep that in mind and look at your state requirements. Because you can get tripped up with a data breach or a privacy violation that can walk you into some legal trouble. Julie, what's your key takeaway for the group?
I already raised it, which is don't just focus on the concerns of the unvaccinated who don't want to get vaccinated, but focus on the people who are vaccinated as well. I would also say consider your risks holistically and your costs as well. As Michele noted, the cost of testing can be quite burdensome. So assuming that you're going to jump to that option as opposed to having a mandate might bring you a world of extra expenses you weren't anticipating. So it's important to think globally about the choices that you're making.
And Michele, how about yourself? Why don't you wrap things up with your crystal ball analysis?
I have no crystal ball, but I can tell you what you can do today. And today is control what you can, right? So we can't control the virus, we can't control the laws that are changing, and we can't control the politics that are feeding a lot of the changing and ping pong that's going on. But you can create a solid plan for your company, right? So that's what we can do is plan. It can include contingencies and even an emergency exit if you need to. But having that plan in action will help your employees move and your company move forward even through all this uncertainty.
Great. Thanks, Michele. And thank you to you all for joining us for this presentation. If you have any questions about vaccines, testing, the changing laws in the federal courts, feel free to reach out to one of the three of us. Our contact information is in the slide deck, and we'd be happy to chat offline. Now we'd like to pass the baton over to Pittsburgh shareholder Alexa Forte and Pittsburgh associate Anna Thompson, who are going to dazzle your minds on immigration challenges and considerations post-COVID. So Alexa, over to you.
Thank you so much. I'm going to just forward the slide. Well, thank you for that very interesting webinar. We're going to shift now the topic from vaccine compliance to immigration challenges and other compliance issues in a COVID-19 world. I'd hope to say it would be a post-COVID-19 world, but unfortunately it still seems that we're mired deep in the pandemic. So I'm going to just introduce myself briefly. My name is Alexa Forte. I'm a shareholder at Dentons, Cohen & Grigsby in Pittsburgh. I've been practicing employment-based immigration for about 30 years, advising clients not only on visa processing issues, but compliance matters and just immigration strategy in how to use their immigration practices to hire foreign nationals or bring foreign nationals to the United States. I'm going to let Anna introduce herself. Anna, if you want to join on camera.
Sure, I should be on camera now. Hi, I am Anna Thompson. I am an associate in the Dentons, Cohen & Grigsby immigration practice based in Pittsburgh. I've been practicing now for about 6 years, and I also advise clients in a variety of employment-based, primarily immigration matters, some family-based cases, and the like.
Thank you. So we're going to focus today on some of the employment practices that have resulted in some compliance issues for our clients as they grapple with how to have employees work off-site or maybe in some flex situation, because those types of changes, as we'll discuss, have important implications for immigration-related compliance. Today, our agenda is going to be discussing some of the LCA or labor condition application and PERM compliance issues that are impacted by changes in work sites or changes in the type of occupation being offered to a foreign national. Anna is then going to cover I-9 compliance issues. Again, these are things that have been impacted dramatically by the inability to look at documents in person in an in-office situation. And then an up-to-the-minute review of consular operations and visa processing challenges. This is certainly one of the more dynamic and fluid of the topics. We're seeing changes to the travel ban situation almost on a daily basis. So the information that we're going to highlight today may be obsolete tomorrow, and actually we anticipate there'll be changes to travel restrictions as soon as Thursday. So the information that we're covering today, of course, is valid as of today. So I'm going to focus first on what we call LCA compliance requirements. So LCA stands for Labor Condition Application. And the reason we wanted to focus on this particular topic is that it is probably the most compliance-driven of the non-immigrant working visas that employers use. So there are a number of types of working visas, but for most of our clients employing temporary professionals in the United States, they're done in the H-1B and its cousin, the H-1B1 category for citizens of Chile and Singapore, or E3 category for professional Australian workers. And these three categories all require that an employer first file this labor condition application form ETA 9035 with the Department of Labor through its flag system. So in addition to having an application filed with the Immigration Service called the USCIS or at a consulate, an employer first must also get the certification from the Department of Labor. So there's an added layer of compliance requirements. In addition to the filing of the labor condition application, employers are also required to post that labor condition application at the work site. And we're going to go through some of the challenges that our clients have encountered as they're no longer maybe at the work site in the office. But just as background, that notice of posting can be accomplished by physically posting the notice in two conspicuous locations at the place of employment. And traditionally, this would be something like the OSHA board or in a meeting room where there's visibility to the employees at the work site. Or it can be conducted by electronic notification via an employer intranet site with all employees having access to or via email. So it's a filing requirement, a posting requirement, and in addition, an employer is required to also maintain what's called a public access file, which provides documentation in the event of an audit to the Department of Labor showing evidence of all the attestations made on the labor condition application. So contextually, the labor condition requirement is based on the concern by the Department of Labor to protect U.S. workers. The idea is that there will be attestations on the labor condition application attesting to the working conditions being offered to the foreign national. So the idea is that the hiring of a foreign national will in no way suppress the working conditions of U.S. workers. It also protects the foreign national because the foreign national can see that it's not getting lesser working conditions than similarly situated U.S. workers. So some of the requirements of the labor condition application form are that the employer must list the offered wage. And the Department of Labor mandates that that wage must be the higher of the actual wage, so the wage offered to similarly situated workers at that particular site, or the prevailing wage, which is the median wage that's basically dictated by the government through an online wage library based on the location of the position and the type of occupation. So keep in mind that the prevailing wage or actual wage for a position located here where I sit in Pittsburgh will likely be significantly lower than if an employee is working in Silicon Valley. And we'll discuss some of the challenges that happen when you move employees across the country, where the prevailing wage may be significantly higher than what you initially indicated on a labor condition application. So very importantly, foreign workers cannot be paid less than U.S. workers, and an employer cannot bench a foreign worker. So any type of furlough situation, you have to continue to pay that H-1B worker the higher of the actual or prevailing wage. In addition, the labor condition application requires that you indicate the exact work site where the H-1B worker will be placed. And that includes, excuse me, any end client location, or, and as we'll discuss in a moment, it could even include now a home situation. So all anticipated work sites must be listed on the labor condition application. In addition, we're required to put the position occupational classification. For example, a software developer or an electrical engineer. The Department of Labor maintains a dictionary of occupational titles. We're required to code that occupational position on the labor condition application, because that will also drive what is the applicable prevailing wage. And it will also drive whether the position is one that supports an H-1B type visa position. In addition, there are various attestations to U.S. and foreign workers on that labor condition application. So all of that is on the form that's electronically filed, and you as the employer are bound to those attestations made on the form. Very importantly as well, as I mentioned before, you also have to maintain a public access file. So the Department of Labor requires an employer have a public access file immediately available to any person wishing to access that public access file, come onto the work site and actually make sure that the employer has documentation supporting how it's determined the actual wage, where it's determined the prevailing wage, and ensuring that the other posting requirements have been met and that the benefits being offered to the foreign workers are the same as those offered to similarly situated U.S. workers. So the issues that we've seen have really arisen with COVID, where there have been a number of changes that have occurred as employees have maybe started to work remotely, maybe have changed occupations. And the Department of Labor regulations indicate that if there are any material changes to the employment details listed on the LCA, a new LCA must be obtained, and an amended visa petition must be filed with the Immigration Service, the USCIS, to reflect those changes. So, we've seen, particularly during the pandemic, that a number of material changes have arisen. And so what are some of those material changes? Well, salary reductions would certainly trigger the need for a new LCA. So if you have a situation, as we saw maybe at the outside of the pandemic, when many employers were reducing the offered wage to their employees across the board, you have to determine if the new offered wage meets the prevailing wage. As I mentioned before, there's this no benching provision. So if you have a furlough and did not want to pay an H-1B worker, this could not only result in a non-compliance situation for your labor condition application, but could result in the H-1B worker losing their ability to maintain their status. So it's something that has to be reviewed, so that if there's been changes in the wages, they can certainly go up, but if they go down, it's something that has to be looked at against the prevailing wage. Other substantive changes that are material would be if the position or occupation substantially changes. So for example, if you've listed on the labor condition application that the position is for an electrical engineer, and perhaps over time now the individual has been promoted to a managerial type position, that might reflect a material change if the occupational classification used on that labor condition application is no longer relevant. You might also have a situation where somebody's had a demotion, or maybe they've changed into a different hybrid role. You have to review those LCAs again to make sure that the occupation listed on the labor condition application remains relevant. Also keep in mind that if you have a situation where somebody's moved into a new role, maybe it's a much higher level role, that may also trigger a higher prevailing wage requirement. So again, you want to make sure before you make those types of changes that you can meet the prevailing wage to ensure that the individual can continue to maintain their H-1B or E-3 status. Very commonly in the beginning of the pandemic, we saw a reduction in the hours worked. Many of our clients wanted to move full-time workers to part-time workers. That can be fine as long as the prevailing wage continues to be met, but it does trigger the requirement of an amended visa petition. So I have many clients that went from full-time to part-time for their employees. We filed amended petitions, and now they're actually bringing those people back to full-time, and now another amended H-1B petition has to be filed to advise the USCIS of the change in the hours being worked. Another material change would be a change in the work location. So again, when you're moving away from the locations listed on the LCA, that can trigger a material change that requires a new H-1B. So there are some carve-outs. So the Department of Labor says where the worksite changes but remains within the metropolitan statistical area, which is defined typically by county, or where the change in worksite is within normal commuting distance, this is the one exemption to the material change in worksite. There, the regulations permit that you can simply post the LCA in the new location without having to file an amended H-1B petition. But keep in mind that, you know, what this normally has been triggered by is when somebody is working remotely. This does require a sort of incongruous situation where you as the employer have to post the labor condition application and the employee's home location in two conspicuous locations. So we have situations where we have employees giving us snapshots of the posting on their bedside table or on their fridge. And then you have to make sure that you're documenting in your public access file the location and the duration of that posting in the home location. And it's relatively surprising that the Department of Labor is mandating that this LCA be posted in a home location because, as I indicated before, the purpose of the LCA is really to give notice to the U.S. workforce of the hiring of the foreign national. So it's not really clear why posting in a home location would actually, accomplish that in any meaningful way. But to date, the Department of Labor hasn't provided any accommodation. They basically indicated that if now the work site is a home location, if it's in the MSA or it's within normal commuting distance, you still need to post in that home location. In terms of what's normal commuting distance, the Department of Labor really hasn't provided a bright line. So normal commuting distance, again, in Pittsburgh, might be very different than for somebody living in Southern California. But generally speaking, anything under 50 miles is considered typically normal commuting distance. But I've had clients argue that in some parts of California, 100 miles might be normal. So it's something, again, that you have to be prepared to document in your public access file in the event of a Department of Labor audit. And if it's something that you're not sure about or you want to be conservative, you can always go ahead and just file a new LCA and a new H-1B petition to reflect that change in worksite location. So certainly during COVID and continuing now, we continue to see closures resulting in remote work. And I think employers and our clients continue to struggle with the compliance issues that have arisen when they really may not be sure where their workforce is. I think sometimes HR and certainly Immigration Counsel sort of last to know. Very often we find out that an employee that we thought was working in the location listed on the labor condition application has now moved across the country. And while that's okay, again, this really does raise implications for compliance on behalf of the LCA. And also raises issues in terms of the individual maintaining their legal status in the United States. So I wanted to cover some of the more common situations with remote workers. So as I mentioned before, so if you have employees that are working from home now, but they're within your MSA or within normal commuting distance, no amended petition is required as long as that labor condition application has been posted within 30 days of the individual moving to that home location. So again, from a compliance perspective, very important to find out where your employee is and has a labor condition application been posted at that work site. If not, I think that would trigger a requirement that an amended H-1B petition be filed to cure that deficiency in posting. What's more clear, of course, is if an employee relocates outside of the MSA, then it's clear. Even if it's temporary, then the Department of Labor requires a new LCA to cover that new position location and that an amended petition be filed with the USCIS. So as soon as you file that amended petition, that does cover that person's ability to work in the new location. So there's no interruption in that H-1B worker's ability to continue to work. And particularly if you've just found out perhaps that somebody has actually moved to a location that was not covered by the initial LCA, It's, of course, very important to talk to Immigration Counsel, but I would advise getting that amended petition filed as soon as possible. Of course, sometimes the challenge may be that somebody's moved to a location where the prevailing wage is significantly higher than the prevailing wage in the initial worksite location. And there may be a situation where if you can't pay the prevailing wage, you might have to require that employee come back to the original location or terminate the H-1B employment. For those employees that have left the country, and we've definitely over the last 18 months seen a number of employees wishing to relocate outside the United States, either for personal reasons or more commonly have left the country at the beginning of the pandemic for visa stamping and now are unable to come back to the United States. The immigration laws regarding posting and LCA compliance are not applicable. So the immigration laws that I'm discussing are only applicable to those located physically in the United States. However, if an individual is outside the United States and you no longer will be pursuing employment with them in the United States, there's no chance that they'll be coming back to the United States, you do want to withdraw that H-1B and LCA so that it terminates your obligations under the LCA filing. If you do terminate an H-1B worker, it's also important to remember that there are certain steps that you have to take as an employer to effectuate a legal termination. So if you separate an H-1B worker, please keep in mind that you are required to withdraw the H-1B, withdraw that labor condition application, as well as offer to the H-1B worker what's called the reasonable return transportation costs. So this is typically the price of an airplane ticket to the individual's home country of last residence. It does not cover moving household goods. It doesn't cover family members. But if you do not actually make that that request for reasonable transportation costs, the Department of Labor could find that you did not actually effectuate a termination and your wage obligations can continue to run under that LCA. So I just wanted to highlight again that in this situation where you have remote workers moving around, you may have them working in a flex situation, you might want to reevaluate how you're posting your LCAs. As I mentioned before, you can do physical postings, but we've had more and more employers now start to use electronic postings as an alternative. So if you have an internet system where you can post legal notices, that might be advisable because then you have more coverage in the event that somebody's moving around and you're not able to post in that home site location. So again, something to look at as you go through your immigration policy. In addition, I think it's extremely important for those employers in particular that have a high number of H-1B workers that you not lose sight of your workforce during this pandemic situation and you make sure that you are doing some type of self-audit of your immigration compliance policies. Obviously, you want to create a comprehensive policy, how to address employees working from home or perhaps coming in on a hybrid model. How are you going to record that LCA compliance? Have you gone through your LCAs and ensure that your public access files are up to date? So even though right now we're not seeing the Department of Labor being as aggressive in terms of doing audits of the public access files or doing on-site H-1B site visits, it's inevitable at some point that that's going to start again. And you want to make sure that you're not in a situation where you've created a tremendous amount of exposure during the pandemic situation. So now I want to shift from the non-immigrant classification of H-1B to the green card because, as I mentioned with the H-1B process, changing work locations, changing occupations can detrimentally impact an H-1B worker's status, and something similar can occur in the green card process. So PERM, or labor certification, not to be confused with alien labor condition application that I just talked about, is a process where an employer, when they start a green card case for an employee, must first get a certification from the Department of Labor that there exists a shortage of minimally qualified and available U.S. workers. So they do that by pursuing a labor market test under a program highly regulated by the Department of Labor. So it's a lengthy process, one that can sometimes takes years, and the green card process for some employees can actually take decades. But in terms of the labor certification process, one of the compliance issues that employers are faced is that they are required to post a notice of filing to its employees, notifying the workforce that it will be pursuing an alien labor certification. So similar to the labor condition application where you're providing notice to the workforce of pursuing something on behalf of a foreign national, there's a similar requirement in the green card or perm process. But unlike the labor condition application where the Department of Labor has permitted there to be electronic posting of that labor condition application, the Department of Labor has not accommodated U.S. employers in the same way. In fact, the Department of Labor has confirmed that an employer is required to physically post that notice of filing at the worksite locations. So recently in liaison, the Department of Labor even instructed that even if no one is at the worksite, even if the office is completely closed, the Department of Labor still requires that you post that notice of filing, literally taping it to the front door or putting it into a front entryway, even if no workers are at site. So, I mean, we've had many employers where they still wanted to pursue perm cases during the pandemic. They may have only had 1 or 2 people in the office, and they're physically posting those notices of filing on site in order to be able to continue with the perm process. Some employers said, they're not able to post those notices of filing, so they suspended the perm process. But I think as more employers start going back to work in some type of flex situation, we're starting to see that notice of filing not be quite the same obstacle to pursuing a perm position. The other sort of important difference between perm and an H-1B in terms of changes in the position is that perm is a process that's based on a future offer. So the position that's being used for the green card does not necessarily need to be the position currently held by the H-1B worker. It's a future position. So if there are changes to the position in terms of the individual now working remotely, but the permanent position continues to remain in office, that may not negatively impact the perm case. But what you have to consider as you review your perm process planning is how do you envision your workforce to be working? Will you be going to a fully remote model? Will this be a flex model? Or do you anticipate that these positions that you're using for permanent residency will eventually come back into the office? It's very important because when an employer is posting positions for perm and advertising for the labor market test, you are required to include in the recruitment the specifics of what is allowed and expected. So if a position is allowed to be at home, that needs to be in the recruitment. So all of that information needs to be included. Right now, what we're advising clients is, if they're not sure, this is an analysis that will have to be done after the pandemic. There are those that say that if right now you have an approved I-140, which is an immigrant visa based on the perm case that was approved and certified by the Department of Labor, that did not reflect the remote work option, and now that remote work option is the permanent option, that may trigger the need for a new perm case and a new I-140. So it's important as you're looking forward so that you do not have to just restart the perm process over and over, that you think about how you want that position to be advertised, and so that the labor market test accurately reflects the actual working conditions that are being offered on a permanent basis. So I'm going to now pass over the presentation to my colleague Anna to talk about some of the I-9 compliance requirements that we're seeing. And I think you're on mute.
Sorry, thank you. So in terms of the I-9 form, this is the employment eligibility verification form that is required to be completed by all U.S. employers on behalf of all U.S. employees in the United States for employment. So an employee within 3 days of being hired and beginning employment is required to produce original acceptable documents to evidence their identity and their ability to work in the United States. The employer is then required to physically inspect and examine the documents to confirm that they reasonably appear to be genuine and to relate to the employee in order to confirm that the individual is eligible to accept employment and to work in the United States. So employers are not obligated to be document experts. They just need to confirm that the documents provided by the employee do reasonably appear to be genuine and to relate to the employee for verification. Obviously, as a result of the pandemic, several employers and really the majority of employers were forced to implement a work from home policy, with the majority, if not all of their workforce going remote, which then of course impacted the ability to physically verify and inspect the documents upon the employee's onboarding. So in response to the work from home policies and the physical, or the, I'm sorry, anyway, in response to these policies, the Department of Homeland Security and the Immigration, Customs and Enforcement, ICE, announced flexibility in the compliance of the I-9 in-person verification. So instead of being required to physically inspect and verify the documents, employers are now permitted employers who are operating on a remote basis are now permitted to remotely obtain and inspect the documents on behalf of their employees. So this policy, this flexibility, is extended through the end of this month. And of course, things are constantly evolving. And as of today, December 31st continues to be the effective date, but it could, of course, be extended as the pandemic continues. This flexibility is allowed for all employees who continue to be working remotely until they undertake non-remote employment on a regular, consistent, or predictable basis, or until the current flexibility is terminated. The requirement to inspect the physical documents only applies to those employees who are working in person on a consistent, regular, and predictable basis. So in terms of I-9 completion of the forms, employers who are operating on this flexibility period should annotate the Section 2 of the form for the onboarding employees that COVID-19 is the reason for the delay in the physical examination of the documents.
Hi, Anna. I just wanted to, I think some of the attendees are concerned that they might have missed the CLE code word. So I think you could.
Oh,
perhaps.
There it is.
So, yes, everyone. So the slide has now popped up for the CLE code word. So it's important that you now take note. The word is evergreen. So we'll just leave it up for a few seconds, Anna, while you go forward with your presentation.
Sorry about that. So, so when you are completing Section 2 of the I-9 for those employees who have been onboarded as a result of the flexibility period, just make sure to mark COVID-19 as a reason for the delay in the physical inspection of the documents. Why is this not? No, I can't go. So once normal operations resume, there will be a requirement that within 3 business days, employees present the original documents for verification on an in-person basis. So employers should be keeping the I-9 files that were completed on during the flexibility period. They should be keeping these files accessible so that they can be completed easily once normal operations are resumed and employees return on a normal, continuous, and predictable basis. This also applies to I-9 re-verifications and to those using E-Verify. When you complete the in-person verification, you can write on the Section 2 again, documents physically examined, and that will go into the file. In the event of an I-9 audit, the date that the documents were physically completed and reviewed will become the effective date for the audit. So the flexibility covers that period as well. We do recommend that employers frequently check with the DHS and ICE websites and with Immigration Counsel because, as I said, things change on a daily basis. As of today, December 31st remains the flexibility date, but this could be extended beyond this year. So in terms of documents that are acceptable for I-9 verification, anytime there is a non-immigrant in a work authorized capacity, upon entering the United States, Customs and Border Protection, CBP, issues an I-94 record. And that record governs the ability to be employed in the United States and for the individual to be physically present in the United States. So the I-94 is a very important document for all non-immigrant foreign nationals in the United States. Those holding a principal visa category, such as an H-1B or an L-1, an O-1, those categories, the I-9 verification can be completed using the I-94 record issued by CBP. For certain dependent spouses, they are eligible to apply for employment authorization through the United States Citizenship and Immigration Services, so USCIS. When applying for the EAD, these spouses, the H, L, and E spouses, must wait before the EAD is actually issued and physically in hand before they can complete the I-9 verification process and before they can begin working in the United States. The EAD document historically needs to be valid at all times during employment and is typically issued in 1 or 2 year increments, depending on the category of the employment authorization. So at the end of the employment authorization period annotated on the EAD, the individual is either required to have a new EAD in hand, or they need to cease employment until the application is, the renewal application is approved and the new EAD document is issued. We are only permitted to submit an application for a renewal of an EAD once we are within 6 months of the expiration date listed on the current document. And unfortunately, USCIS has been taking oftentimes more than 14 months to process and approve the EAD application. So over the last 18 months, especially with the COVID pandemic, several spouses in these employment categories have been without employment, or there has been a major gap in the employment authorization period because the processing times at USCIS significantly exceed the amount of time that we are given to submit a renewal application. And unfortunately, USCIS has very strict and high standards for any expedited processing of the EAD. So a lot of these foreign nationals have been left without employment authorization and with very little opportunity to expedite their cases. Recently, in November, as a result of a legal settlement, USCIS has updated its policy manual to, one, allow for an automatic extension of certain EAD categories, and to allow certain non-immigrant categories of dependent spouses to become employment authorized incident to status. So in terms of the 180-day automatic extension, as long as a renewal application is filed in a timely manner, the individual has a facially expiring or expired EAD document and their I-94 record issued by CBP when they enter the United States, as long as that record remains valid, the individual in H, L, or E dependent status is eligible for a 180-day extension to their EAD document. Once the 180-day extension applies, they are permitted to continue working for the earlier date between the 180-day extension and the I-94 expiration issued by CBP, or an EAD denial, and hopefully is not the case by USCIS. So it's really important for employers when going through the I-9 re-verification process with someone with an EAD, it is very important to understand which of the two dates is controlling between the 180 days and the I-94 expiration. So for this reason, it's important to speak with Immigration Counsel and to make sure that the employee understands exactly which date controls their employment. In terms of I-9 re-verification for someone in this situation, the employer should accept the EAD document that was initially issued, a copy of the receipt notice for the pending timely filed renewal application, and a copy of the unexpired I-94 record. So those three documents can be used to re-verify someone's I-9 so that they can continue working during the pendency of their EAD renewal application. In addition to the 180-day extension, USCIS updated its policy to now allow L2 and all spouses of E categories to be authorized for employment incident to status, which means that an EAD document will no longer be required for these non-immigrant spouses, which is a huge shift, a very positive shift for people who qualify for this category. Instead of using the EAD for I-9 verification, just like the principal visa holders, the I-94 record will be used for I-9 verification. In order for this to happen, however, CBP needs to make changes to its internal processes. Currently, there's no difference between an I-94 that is issued for a spouse or for a child, and the spouses are the only dependents that are eligible for employment currently. So CBP is in the process of making changes to its I-94 internal process to annotate the I-94 records for dependent spouses so that they can use their I-94 record for I-9 verification purposes. In the meantime, there is an argument that the spouse must have either a valid EAD or be eligible for the 180-day extension that I just spoke about. So the settlement directed USCIS to make its changes before March of 2022. They were given 120 days to make their changes, which they have made their policy changes. Now we are expecting to see CBP make their end of the changes against the same deadline. So this is very welcome news for a lot of people, and hopefully we see CBP make their changes soon. Otherwise, the EAD is required, or a 180-day extension should be looked for in terms of I-9 verification. Unfortunately, for H-4 spouses, the spouses of H-1B visa holders, there is no employment authorization incident to status, so those individuals will still require an EAD for I-9 verification or an automatic extension per the information I just discussed. So I just want to switch gears a bit to talk about the implications of the pandemic on our consular operations and processing. So in order to travel to the United States, either as an immigrant visa holder, which is a permanent resident, or as a non-immigrant visa holder, which includes the employment-based temporary work categories, visitors, students, etc., an individual must carry and possess a valid travel document. And in order to apply for and obtain the travel document required for entry to the United States, the individual must attend an appointment at the U.S. consulate or embassy in their country of location. And as a result of the pandemic, all U.S. consulates and embassies ceased operations and were closed for several months during 2020. Following the closures, the consulates and embassies have implemented a phased reopening to resume their processes. However, we are still seeing significant backlogs and a delay in the appointment availability. I can think of maybe five locations right now with immediate or regular availability for different visa categories. So we're still in a situation where it's very difficult to obtain an appointment either for an immigrant visa, for the green card categories, or for a non-immigrant temporary work or visitor visa. Given that the consulates are not able to resume their full capacity and operations, the Department of State has implemented a system of priorities in order to process the the applications of the non-immigrants and immigrants abroad. Importantly, the United States citizens have been given the top tier of priority. So any U.S. citizen abroad is given priority in terms of the needs at the consulates. Next on the priority list would be the immigrant visa categories, which are then themselves broken into different subcategories and prioritized as well. And then the lowest level of priority would be the non-immigrant, which are the temporary categories. Again, within the green card categories, the special preference is given to intercountry adoption cases, special immigrant cases, and emergency applicants, which include healthcare workers. In the same tier, the same priority would be the immediate relatives of U.S. citizens, so U.S. citizen spouses and children and their fiancés. From there, the third and fourth priorities are given to the remaining family preference categories, so siblings, unmarried children who are over 21, and other specific categories within the family area. And then, of course, the employment-based immigrant visa applications. Again, the non-immigrant categories are prioritized at a lower level than the green cards. And within that specific grouping, again, there are several different types of non-immigrant visas, and they are each prioritized as well, with diplomatic, student, and exchange visitors given the highest priority in terms of visa appointment availability, followed by temporary workers, and then the last priority is given to the tourist visas. Even given the priority system that has been in place, the availability of appointments really is dependent on in-country conditions in the locations and the staffing available at the consulate. So again, it's very difficult to obtain visa appointments and to get people back to the United States or into the United States on an initial basis. In order to get the appointments, we have had to look at having people travel to different countries to find, different countries that have maybe more availability, because it is still very difficult to find openings at various locations. In addition to the issues in obtaining appointments and the lack of availability, we have been facing significant travel restrictions in order to protect the safety of the U.S. populations. The Trump and Biden administrations have both implemented presidential proclamations to restrict travel directly to the United States when an individual is physically present or has been physically present within a number of countries prior to their travel to the United States. So although these specific travel restrictions are no longer in place, they affected 33 different countries, the entire Schengen area, which includes 26 countries, China, Iran, India, the United Kingdom, Ireland, Brazil, and South Africa. So anyone who was physically present in any of those countries within 14 days of their expected travel to the United States was barred from entering the United States unless they fell into a specific list of exceptions. So spouses and children of United States citizens, legal permanent residents, and a number of other limited exceptions. One option for those who were affected by the physical presence travel restrictions would be to spend 14 full days in a non-restricted country. So we saw people spending time in third countries in order to effectively quarantine. And if they were not able to do that, the only other option would be to request a national interest exception from the United States consulate in the location where the individual was located. So we had to effectively argue to the consulate that someone was eligible based on a limited criteria, either that they were operating at a senior level within their company, that they were working in one of very few occupations in order to be eligible to travel directly to the United States. Those restrictions were rescinded as of November 8th in favor of a requirement that now all foreign national travelers to the United States be fully vaccinated against COVID-19 prior to travel to the United States, and they're also required to present a negative COVID-19 test taken within 3 days of travel. So while the previous physical presence travel restrictions have been rescinded, there is now a new policy in place requiring vaccination and testing for foreign national travelers. In addition, just a few days ago, the administration implemented a new proclamation affecting foreign nationals in 8 countries in Africa. So anyone subject to the new physical presence travel restrictions either need to spend 14 days outside of the restricted countries, or they need to obtain a national interest exception from the consulate in their location in order to travel directly to the United States. Any brief layover in any of these countries is considered physical presence for purposes of the restriction. So even spending 15 minutes at the airport triggers the restriction, and a national interest exception would be required, or the individual would need to travel to a third country not listed on the travel restriction list.
Thank you, Anna. So I think as we come to the conclusion of our presentation, I think the summary and some of the takeaways that we wanted to emphasize is that it's very important that employers with foreign national populations do audits, review their compliance issues as a result of COVID-19 remote work changes. That's very important. So not out of sight, out of mind, but keeping mindful of where your workforce is. And of course, being vigilant about the existing regulatory compliance requirements, because things are changing rapidly, as Anna and I indicated today. There are changes happening in terms of travel bans, requirements for coming into the country. She mentioned the vaccination requirements. There have been discussions that on Thursday, the administration might require that the COVID testing protocol be within 24 hours of a flight into the United States, and that would impact U.S. citizens and permanent residents as well. And as well as we go into this holiday season, if you have foreign nationals anxious to travel home, as we often hear about and see, again, a very frank conversation has to be had about what could be the implications of their ability to return to the United States. Travel bans are popping up with little to no notice, as we saw last week with Southern Africa. So, even if an individual doesn't have a travel ban at this point, there's always a chance they could be stuck abroad. And as well, with the consular operations being so limited, particularly during holiday seasons, if somebody does not have a visa and requires one, they can't expect that they might get that visa while they're home for, Christmas holiday type of thing. So very important to warn employees about the risks of international travel. Where possible, we recommend against it. Obviously that's very hard to hear for a lot of people who are very anxious, particularly over the last 18 months during their inability to travel home and see family. But there are significant risks with international travel, so it's just better to be aware of those before they get stuck abroad. So I believe that brings us to the conclusion of our presentation. Again, if there are any questions or topics that we didn't cover during the presentation, we're happy to talk about those offline. Our contact materials are in the presentation. Thank you again for everybody who's come today. As mentioned earlier at the outset, all the presentation materials are available for download from the materials box found in the upper right hand of the screen. They're also available on our event website and have been included in your confirmation emails. In approximately 15 business days, you'll receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates, so no additional steps are required. As a reminder, the code word requirement is only if you're seeking credit in Kansas, New Jersey, New York, and/or Pennsylvania. CLE credit for the live webinar has been approved for 2 hours of general credit in Arizona, California, Illinois, Indiana, Iowa, Kansas, Missouri, New Jersey, New York, Pennsylvania, and Texas, and is pending approval in Georgia, Kentucky, Utah, and Virginia. So again, thank you all for joining us, and we hope to see you at our next webinar next year. Our winter 2022 season will kick off on Wednesday, January 19th. Please stay tuned for email communications in your inbox, or reach out to any of our presenters today or your usual Denton's contact for more information. So again, thank you so much, and we wish you all a very good day.